I would like to call to order the October meeting of the Morrisville Planning and Zoning Board. If you will please join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Any changes to the agenda, any last minute items that actually came in? No. I will entertain a motion to approve the agenda.
Make a motion to approve the agenda.
Do we have a second? Marky seconds. All in favor?
Aye.
Aye, that carries unanimously. Any changes to the minutes? Any notes?
No.
Then I will entertain a motion to approve the minutes.
I make a motion to approve the minutes.
Do I have a second?
Aye.
She second. Darky second that. All in favor?
Aye.
Aye. That carries unanimously. So we can move on to presentation number 5.
Okay, well, good evening. We have a couple more trainings for you this evening, very similar to the trainings that you received at the last meeting. I think last month you heard a couple webinars from the School of Government presented by Adam Lovelady. Tonight we have a couple more School of Government webinars. This time you're going to hear from Jim Joyce. The webinars from last meeting were focused on legislative decisions. And those are the ones that you most frequently see. And that's where you and the town has very broad discretion because you're establishing the rules, either through a rezoning or through a text amendment. Tonight, you'll hear a little bit about quasi-judicial decisions. We don't see many of those, but they are very different. And they have very different legal procedures that go along with them. It's very court-like in terms of the evidence you can consider, the individuals that are allowed to speak. Throughout both of the modules, you'll hear references frequently to special use permits and variances. Those are our two most common types of quasi-judicial decisions. There are more, but those are the two most common. Special use permits are reviewed by the town council. So just know that as you go through, as you're hearing about special use permits, good to learn, know about, but those are reviewed by the town council. The zoning variance requests are reviewed by the Planning and Zoning Board. You may hear some reference to the Board of Adjustment reviewing those, but just a reminder or new information for some of you that haven't been around as long. The town dissolved the Board of Adjustment a few years ago. We were allowed to do that by state statute. We don't see many variances, so that authority was granted to the Planning and Zoning Board. So you are the ones that do review the variance applications. But with that, I'm going to jump in. I think both of them are like 20 to 30 minutes long, and I guess I'll just go ahead and kick it off. So I think I want to do... Can't remember which one's first. I'll do the process one first.
I'm Jim Joyce, faculty member here at the UNC School of Government. In this module, we'll talk about quasi-judicial process, the procedures for making quasi-judicial land use decisions, what the formalities are, and why they are this way. It all starts with due process. When someone is a party in a court of law, our constitutions, state and federal, entitle them to some due process. That just means a fair and reasonable process. Just like people are afforded those rights in a judicial context, we give people, we honor people's due process rights in a quasi-judicial context as well. Here's what that means. It means that a party in a quasi-judicial proceeding has a right to clear guiding standards, a notice, an opportunity to be heard at some hearing or tribunal meeting. They have a right to their decision being made by an impartial decision maker based on the evidence in the record. And if they don't like it, they have a right to an appeal. So we're going to talk about each of these due process rights in a little more detail as we go through the process, walk through the process of making a quasi-judicial decision. So let's say local government gets an application in. We need some guidance for how to decide the case, right? We need those clear guiding standards. I want to step back for just a moment to talk about who gets those due process rights, because not everyone in the community has the same right to participate in the quasi-judicial proceeding. Think about, again, we can think by analogy to a judicial proceeding. If there's a trial going on between two different parties, I, as a member of the public, don't have due process rights because it's not my interests that are at stake. So we try to limit certain participation to folks who have a stake in the quasi-judicial decision. Our statutes define that as standing. Someone who has standing has an adequate kind of stake in the game. The statutes define these parties as the ones who have standing. First, the property owner or someone who holds a property interest, like a purchase contract for the piece of property that is at issue, the subject of the variance or special use permit or what have you. Then the applicant, the person who's asking for something. There's also another category of folks who have standing. This is a tricky one, and it's actually fairly narrow. Other property owners who would suffer special damages as a result of the quasi-judicial decision that's made, they can also participate as parties. But that range of people who suffer special damages is pretty narrow. It really has to be a unique effect. So if I'm applying for a special use permit to put in a small apartment building on the little lot where my home currently stands, then while, say, people who live next to me would certainly be affected by the result of whether I get my special use permit or not, they're all affected in a similar way. To have special damages, you would have to have a situation like this. I live in the Piedmont region of North Carolina, so of course my house sits on a hill. Let's say I'm seeking a special use permit to put in a small apartment building, and the property owner across the street is downhill from me. So if I alter the way that stormwater flows across my property, or put sediment or other things out there that might go onto their property, now that neighbor is being affected in a way that other neighbors in the area are not. So they would suffer special damages. Think of it this way. We take the general public's concerns and opinions into account when making the legislative decision to set the standards. Right? When we have a use designated as a special use on our zoning ordinance table of uses, then that means we're okay with that use in that area as long as they meet certain conditions. So in deciding those conditions and in voting on the legislative text and table, that's where the general public gets its say. To have standing in this quasi-judicial case, we need something very peculiar to a particular property owner. There is one other party that has standing, but that really comes up largely in the context of an appeal of a quasi-judicial decision. The governing board of that same local government has standing to participate in the quasi-judicial case and, more importantly and more frequently, to appeal the decision of their own board of adjustment. So those are the parties to whom that due process is due. Now let's talk about those clear guiding standards, right? We had clear guiding standards, notice and an opportunity to be heard, an impartial decision maker, a decision based on the evidence, and a right to an appeal. So what do we mean by clear guiding standards? How clear do they need to be? If you look at the standards that are on this slide, these are not measurable standards or ones where it's easy to say, look at a plan and check a box. If they were those kind of more straightforward standards, we'd make what's called an administrative decision, which is a different process. Here, look at some of these standards. The establishment, maintenance, or operation of the special use will not be detrimental to or endanger the public health, safety, and welfare. The special use will be in harmony with existing development. Skipping down, it will not substantially injure the value of adjoining property. We can't look at a map or a plan and figure out whether these conditions are met or not. What we need is the full facts of the situation and an impartial decision maker who can sift through those facts and apply them to our standards. So to be clear guiding standards for purposes of due process, they just need to kind of direct the board. What is it that I need to be looking for as a board member? If I'm applying these standards, then I need to be thinking about public health, safety, and welfare. I need to be looking at whether there's adequate infrastructure, how it fits into the surrounding area, and what impact it might have on property values. So it's not that precise check the box, measure the setback, but it gives the board something to go on. Here's what we're looking for. Here are the criteria that we're going to apply so that it's not just a wide open, should we grant this special use permit or not? All right, let's talk about notice and an opportunity to be heard. State law requires that notice be given to the owner of the property, the applicant, and owners of adjacent property. Usually that's mailed out. There are a couple of exceptions for local governments that can send those out electronically, but for the vast majority of North Carolina local governments, those need to be mailed out and there needs to be a sign on the property. Now, this is the minimum notice required by state law. Many of your ordinances will require additional notice. For example, there are a number of local governments throughout the state that require that notice be mailed to the owner, the applicant, and owners of property, say within 100 feet of the subject property. So when looking at the notice requirements for your particular jurisdiction, it's important to look at your ordinance to see if there are additional standards above this minimum that the state law sets. So that's our notice. And since we're giving notice of a hearing, yes, we're going to have an opportunity for the parties with standing to be heard. Now, parties that have standing, again, that's the applicant, that's the property owner, that's those folks with that, who would suffer that special damage. They can do the things that we would see in the courtroom dramas, right? Cross-examining witnesses, making legal arguments, objecting to the submission of certain evidence. Now, it is often the case that a local government board of adjustment will allow, and indeed probably should allow, members of the public to come and provide their own testimony and present their own evidence. A board can allow anyone to present evidence. As we'll see, there are standards for that evidence. But someone who is not a party withstanding can't act as a party, do this cross-examining and making legal arguments, etc. So we've got our clear guiding standards, our notice, and our opportunity to be heard. Then we move into kind of building on that opportunity to be heard and the hearing itself, right? We've provided notice. Now we're at the evidentiary hearing where we're going to take evidence and the board is going to decide whether to grant this quasi-judicial, approve a quasi-judicial application or not. Now what you see on your screen is the usual process, what we see most often across the state. This process isn't mandated by state law, but having an opening, an introduction, and then the presentation of evidence, and then time to deliberate, and that final decision help to preserve some of those due process rights to impartial decision makers and evidence-based decisions. Then, of course, we get to appeal afterward if we don't like it. So, when talking about an impartial decision maker, here's a handy quote from the North Carolina Court of Appeals from just a few years ago, and they said in quasi-judicial proceedings, no board or council member should appear to be an advocate for or take an adversarial position to a party. They shouldn't bring in extra or incompetent evidence, and they shouldn't rely on ex parte communications. What we're going to talk about in the next couple of minutes is how we tease that out and avoid those pitfalls in terms of being an impartial decision maker or not. Now, usually at the opening of the hearing, there is an opportunity for us to kind of not just introduce the case, but oftentimes there's an opportunity for board members to disclose anything they need to disclose or to recuse themselves if anyone needs to recuse himself or herself. More about that in just a moment. Another part of the quasi-judicial process that isn't the case in, say, legislative decision-making, where we're deciding what the rules should be. In quasi-judicial decision-making, we have to swear in witnesses. Some boards like to do this all at once, have everyone who wants to testify stand up and raise their right hand and swear to tell the truth, etc. Some jurisdictions prefer to do it when each witness comes up. Either way is valid, but those are the two ways that I've most commonly seen swearing in of witnesses in the state of North Carolina. All right. So digging deeper into that first phase and the opportunity for disclosure and recusal. Usually when we're talking about a board member making a quasi-judicial decision and disclosing something, they're going to disclose ex parte communications or that they've made a visit to the site. And we'll talk about the conflicts of interest that make it so a board member has to recuse himself or herself from making the decision. First, ex parte evidence. This is taking in evidence when not all of the parties are present. Generally, we want to try to avoid taking in ex parte evidence or talking to folks outside of the hearing about the substance of the hearing. Those ex parte communications, again, should be avoided, but have to be disclosed at some point during the hearing. That's why we often make a little time for them at the beginning, but it can be at any time. Now, it's important to note that ex parte communications, when we have to disclose, that's when there's some sort of substantive communication between the board member and either staff or a member of the public about the substance of the case. If I run into someone in the line at the grocery store and I'm a Board of Adjustment member and they ask me what time this controversial variance is going to be heard by the Board of Adjustment, or I talk to staff about whether a particular special use permit case is on our agenda for this meeting or the next, those don't need to be disclosed. You can have as many communications as you want about the kind of logistics and the context of the proceeding. Where we get into trouble is when there's communication about that is relevant to the standards that we're applying, right? When it's about the substance of the case. That's when we have an ex parte communication that should be disclosed and that a board member should not rely on when making their decision. I want to talk a little bit in particular about site visits. Some board members, individually or in groups, like to go and drive by or walk by the site of a property that is the subject of some quasi-judicial proposal. Those are fine, but they are also ex parte, right? You're looking at some of the facts of the situation outside of the hearing, so those need to be disclosed. I want to mention something else about site visits. If your board does go for a site visit, they need to do it either singly or with less than a majority of the board. Because anytime you have the majority of the members of a public body getting together to do some public business, that needs to be an official meeting under North Carolina Open Meetings Law. So those site visits are okay, but we have to disclose and we have to make sure that we're not violating the open meetings laws when doing so. So that's ex parte evidence. That's the disclosure part. Now let's talk about the conflicts of interest, the recusal. When does someone need to recuse himself or herself from a quasi-judicial proceeding? First, I want to mention what we mean by recusal. Certainly, someone who is recused from a case can't vote on it, can't deliberate on it, shouldn't be asking witnesses questions. Basically, it needs to be as though that board member doesn't exist, sort of phase out. Some boards will even require their board members who are recused to leave the council table or wherever the board is gathered. That's not necessary, but the effect should be substantially similar. If I've recused myself from a particular case, then I need to take no part in it. That way we help make sure that the board is acting as an impartial decision maker. So what kind of conflicts create conflicts of interest that require this drastic step of recusal? There are three kinds that are described in the state statutes. Again, this is going to be a baseline. So your ordinances or your board procedures might have some additional requirements. Here are the kinds of conflicts. One, a financial conflict. If the outcome of a quasi-judicial case would have a direct, substantial, and readily identifiable financial impact on a member of the board, that member of the board has a conflict of interest and they need to recuse themselves. Now, of course, this needs to be something that is fairly certain and a direct financial impact, right? If I have a contract in hand to lay concrete for proposed hotel that's the subject of a special use permit hearing before me, I have a financial conflict and I need to recuse myself. If I have a retirement account that invests in a mutual fund that invests in a real estate, blah, 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 and there's a bunch of steps, or it's not clear that I would financially gain from the project, then we don't need to worry about it. The second category of conflicts deal with relationships. If a board member has a close family, business, or associational relationship with basically one of the folks who have standing, then that board member needs to recuse himself or herself. Interestingly enough, this close family relationship is in fact defined in the statutes. It's roughly a nuclear family. You have, if the relationships are grandparent, parent, spouse, sibling, child, or grandchild. And that applies whether those are blood, in-law, half, or step relations. So at a minimum, and again, this is kind of the state baseline, I can't hear a variance case that my brother submits or my brother-in-law. The business relationship doesn't have to be connected to the special use permit. I might want to approve my business partner's special use permit even though our special use permit is, even though the special use permit doesn't relate to our business together, we've got that relationship where one might start to wonder, is this board member making their decision based on the relationship instead of making the decision based on the evidence? That's when we have real, that's when if there's a situation that's on the borderline, someone should recuse themselves. If there's a substantial chance that someone from outside would be concerned that a decision is being made on the basis of a relationship instead of the facts, then we need to consider having someone recuse himself or herself. Now, this associational category that hasn't really been defined by statute, regulation, or case law, so that's really up to the good judgment of the board and the good and reasonable judgment. So that's where this kind of touchstone of would someone be afraid that it's that the decision is being made based on the relationship. The other kind is kind of bias or perspective. So if a board member has undisclosed ex parte communications or is biased, I'm about to talk about that, then that board member should not be participating in the quasi-judicial case. And what we mean by bias is not that there's kind of a predilection to vote for or against. This is if someone has made up their mind. You have a fixed position that you are not going to change before the hearing, then you're biased and you need to remove yourself from that quasi-judicial case. Now, this neutrality conflict is probably going to be brought up most often on appeal, but that's when they apply. If there's undisclosed ex parte communications or someone has already made up their mind before the hearing. It may be that I'm not particularly inclined to vote for Ken's proposed variance, but I'm going to look at all the facts and make my decision then. Then I'm fine. I don't have a conflict there. It's only if we've made up our minds in advance. Again, your board may have procedures or your local government may have rules that build on this baseline, but this is the state law baseline that applies regardless of where you are. Now you might be thinking, what if there's a conflict about the conflict? What if not everyone agrees that a particular person should be recused? then the board can discuss that potential recusal. And the board then votes by, can even vote by majority vote whether someone needs to be recused or not. So there can be some discussion and vote if that's appropriate, if that needs to happen, to determine whether there's need for someone to recuse himself or herself from a quasi-judicial hearing. All right, now let's move on to the presentation of evidence. We've got our notice, we've got our hearing, we've done some work of figuring out if there's a reason why anyone needs to disclose something or not participate in the case. Now let's get to the hearing itself and the presentation of evidence and making the decision. I'll note there is another module on deciding quasi-judicial cases that discusses the evidence and this deliberation in a little more detail. First of all, what kind of evidence is presented? Some of it will be witness testimony, and some of it will be in the form of documents. Now, for testimony to be, we call it competent, material, and substantial. For evidence to be the basis of a quasi-judicial decision, that evidence needs to be competent. In other words, someone needs to know firsthand, have facts in front of them. That testimony needs to be material. It needs to relate to the standards and the land use impacts of what we're looking at. And it needs to be substantial. Now that means, we don't mean substantial in terms of there has to be a lot of it. Really, we mean substantial in that there's some substance to it. So that can come in the form of firsthand testimony, speaking from firsthand experience. I'll note that if we're talking about something that's going to happen in the future, right? We're giving an opinion about what might happen if a particular project is approved. That's an opinion. And there, for that testimony to be competent evidence, we need to have an expert provide that opinion. So when we looked at clear guiding standards, recall that one of those related to not injuring the value of surrounding property. There, the applicant is probably going to need to have an expert, an appraiser, come in and say something about how the proposed project would affect surrounding property values. They need to have kind of done their homework to prepare for giving that opinion. The other kind of evidence comes in the form of documents. That starts with the application and other documents that might have been submitted before the hearing. It also might come in the form of things that are passed up at the hearing. So any of this testimony or documentation can be the source of evidence that the board is going to base their quasi-judicial decision on. So let's talk about the process of making that decision. That decision has to happen in an open session before the public. There's no going into closed sessions if it's particularly sensitive. There are reasons why North Carolina boards can go into closed session, but those are very limited. And most of those, if not all of them, will not apply to making a quasi-judicial decision. So we've got to have our deliberation in open session, and it should focus on the evidence that's been presented and how that evidence matches up with the standards that are in our ordinance, or in the case of variances, the standards that are in state law. When making that deliberation, the board's decision can be to approve the application, to deny it, or to approve it with conditions. But if we approve with conditions, those conditions have to relate to the standards that we're applying and the land use impacts of the proposal. When it comes time to vote, we need a 4/5 majority to grant a variance. Only a simple majority will do for other quasi-judicial decisions. And once that decision is made, it needs to be reduced to writing. We need to have a final written decision that includes findings of fact and applies the board's reasoning of how those facts lead us to finding that the standards in our ordinance or the standards that we're applying in the quasi-judicial case are met. So that's the final decision. Approve with conditions that relate to the standards and land use impacts, or deny. When we reduce that to a final written decision, that is a key part of what a court looks at if there is an appeal. Now, for most quasi-judicial decisions, the appeal goes to Superior Court. That's your local county court. It's called a petition for a writ of certiorari, which is a fancy legal term that relates to some fancy legal technicalities, but it's an appeal. Effectively, you're appealing to Superior Court to challenge a Board of Adjustment decision. Courts will look through the record. They'll look for various kinds of legal issues, exceeding authority, for instance, in applying some conditions. They'll also look to make sure that the decision that was made is backed up by some competent material and substantial evidence. Now, when the Superior Court does this, they don't have a whole new factual hearing. That appeal is based on the record that has been put together by the local government. So that becomes the basis of the appeal. So now we've gone through clear guiding standards, notice, an opportunity to be heard, some steps we can take to make sure we have an impartial decision maker, making our decision based on evidence, and a right to appeal. That's the quasi-judicial process in a nutshell. Again, I'm Jim Joyce. Thank you for watching.
Okay, so that is module number 1. As I'm bringing up module number 2, you just heard about appeals. Just a reminder to the board, majority of the time, the Planning and Zoning Board acts in an advisory capacity where you're making recommendations to the town council. The one exception to that is variances. You have final decision-making authority on variances. So if there is an appeal that does not go to town council, there is no town council involvement at all in a variance request. It simply goes to the Planning and Zoning Board, and then if appealed, straight to Superior Court. So I wanted to make sure you were aware of that as well. Okay, so one more here for you. Hopefully the sound.
At regular speed, it seemed awful slow.
I think
yes,
he's just
Jim
trying to be
Joyce
slow.
could be a little.
I mean, they're trying to make sure people have time to absorb the material.
Well, I was just checking, there was a volume problem, I thought maybe.
That was normal speed. I think just trying to be clear for everyone.
Hi, I'm Jim Joyce with the UNC School of Government. My area of focus is land use and local government jurisdiction, which includes deciding quasi-judicial cases. And that's what we're going to talk about in this module. So this is the touchstone for deciding quasi-judicial cases. This quote is in the statutes, General Statute 160D 406J, and it gets repeated whenever there is a case before the North Carolina Supreme Court or the North Carolina Court of Appeals about quasi-judicial decision-making. And as you can see, that is that every quasi-judicial decision must be based on competent, material, and substantial evidence in the record. And when we talk about deciding quasi-judicial cases, that's what we mean. We're talking about how we look at that competent material and substantial evidence in the record and the need to focus on that and not other potential concerns. So what do we mean by competent, material, and substantial evidence? Well, we have a recent decision from the North Carolina Court of Appeals that describes in a little more detail what we mean by competent, material, and substantial. Competent evidence is relevant and admissible. It's reliable. Right? You have someone who is testifying from firsthand experience, for example. Or if we're talking about if someone is presenting an opinion, they're an expert. That's competence. Material evidence is evidence that has some connection with the facts of the case and the issues presented. It is relevant to the decision that we're making and to the standards that we have to apply. Lastly, substantial evidence. The language of the case is that it consists of more than a mere scintilla, and such relevant evidence as a reasonable mind might accept as adequate to support a conclusion. Well, put it differently, substantial evidence doesn't mean piles and piles of uber convincing evidence. Substantial evidence means that the evidence that's presented has some substance to it. It tends to make it more likely that someone could find one way or the other in a quasi-judicial case. So competent, material, and substantial evidence is what we're looking for in the quasi-judicial hearing, and that's what needs to be the basis for the board's decision. Now, let's talk a little bit about witness testimony. Witnesses should be sworn. This may be done as individual witnesses come up. Some boards will even swear in everyone who wants to testify on a case at the beginning of the case. One way or another, however you do it, the witness has to be sworn in. And they have to be testifying to factual information, something that is supported by their firsthand knowledge or document evidence. And it needs to be focused on the standards that are being applied and the land use impacts of whatever is being proposed as part of the quasi-judicial decision. Very important to stay focused on those standards and the land use, and not the owner, the applicant, tenants, future residents, someone who's involved otherwise with the project. A special use permit or a variance, any other quasi-judicial decision relates to a particular land use, this use on this property. The character of the owner or the history of the applicant, those aren't about the land use on the particular property. And so those are not to be part of, those are not statements that can be part of what the board uses as the basis for its decision. We can't stop anyone from providing different testimony, but the testimony that the board relies on needs to be factual and focused on the standards to be applied and the land use impacts of the proposed use. In addition, if we have someone who is presenting an opinion, as I mentioned a moment ago, if we're talking about something that will happen in the future, that opinion needs to be given by an expert. This is different from legislative decision-making. When we have a text amendment or a rezoning, in that context, people might talk about what they think is going to happen. But in a quasi-judicial decision, and that may have limited value in a legislative decision anyway, but in a quasi-judicial decision, if I'm going to testify about what's going to happen with, say, traffic property values or other kind of technical matters, we need that opinion to come from an expert. Here's an important distinction. I can testify to what traffic is like on my street on an average day. I live there. I see cars going by. I may or may not be able to give, I probably won't be able to give an accurate count, but I can give a general idea. I have I have firsthand knowledge of those facts, but I'm not a traffic engineer. And so I can't present my opinion about what's going to happen to traffic on my street if some quasi-judicial decision is made that allows a particular use, say in my neighborhood or next to it. That opinion has to come from an expert. One note about testimony. Boards can limit the amount of time that an individual might testify. Usually, it's okay to give a little more time to the applicant because they are the one who has the burden of proof, as we'll talk about shortly. But reasonable limits, fairly applied, can be put on the length of someone's testimony. It's often helpful too, maybe at the beginning of a quasi-judicial hearing, to remind the public that in a quasi-judicial case, we need facts. For those of you who are of my generation or before, we're like Joe Friday. We need you to give us just the facts, unless you're an expert. So that's witness testimony. Again, it has to be focused on the standards and the land use impacts as well. The other kind of testimony, the other kind of evidence that we may have in a quasi-judicial case is document evidence. This includes the application, staff reports, responses to requests for additional information, any documents that were submitted and distributed before the hearing, or documents that are presented at the hearing. I might have my 8x10 color glossy photos with circles and arrows and a paragraph on the back of each one that I pass up to members of the Board of Adjustment at the hearing. That's also document evidence that needs to be part of the record. So there you have it, testimony and document evidence. Important to note that we also have to make any objections at the hearing. So if there's a party who wants to object to a particular piece of evidence, that objection needs to be made at the hearing. All right, so we've gotten all the evidence. You've collected competent material and substantial evidence. We've gotten firsthand knowledge. We have some expert opinion, perhaps. All of the documents that came forward in the case, whether before the hearing or during the hearing. Now it's time for the board to deliberate. And the board needs to do that in open session, even if it's uncomfortable. In North Carolina, we put a strong emphasis on government transparency, especially at the local level. And so deliberation about a particular quasi-judicial decision needs to happen while we're still in open session. There are only a few situations in which a board can go into a closed session, and those are almost never going to arise in a quasi-judicial case. The board also needs to be focusing on, just like the evidence, they need to be focused on the standards that are being applied in the quasi-judicial case. These are either the standards that are present in an ordinance relating to special use, or they might be focusing on the 4 criteria that are in state law for granting a variance. In either case, we're focusing on the evidence and how that matches up with the standards. So in that deliberation, how do we decide Who to vote for? Well, there are some clear rules about the burden of proof in a quasi-judicial case. And I like to think of it in terms of the scales of justice. Right? You always have justice holding up this scale. At the beginning of the hearing, the scales of justice are tipped away from the applicant. The applicant has the first burden of proof. They need to provide competent, material, and substantial evidence that would tend to show that their application for a special use permit, variance, what have you, meets the criteria that are being applied. In legal terms, we call this making your prima facie case. If an applicant does not make their prima facie case, the scales of justice remain tipped away from them, and they don't get whatever it was that they're applying for. However, if the applicant provides, or someone on their behalf provides competent, material, and substantial evidence that tends to support a finding that all of the standards to be applied are met, then the scales of justice tip the other way. If the applicant is the only party or the only person that presents competent, material, and substantial evidence, or if all the competent, material, and substantial evidence supports the applicant, then they are entitled to whatever quasi-judicial approval they were looking for. The board actually doesn't have the authority to deny a quasi-judicial application when the applicant has met their burden of proof, but there's no competent, material, and substantial evidence going the other way. So once the applicant makes their prima facie case, the scales of justice tip in their favor. If the opponents of whatever project is being considered, if the opponents of that special use approval then provide their own competent, material, and substantial evidence, well, now it's for the board to weigh the evidence and decide based on these contested facts, who has the better argument or who has the better evidence. So it's that scales of justice starting out opposed to the applicant, then they make their case and the scales of justice tip in their favor. And then when we put some more competent, material, and substantial evidence on the other side, now it's up to the board to weigh that evidence. In doing so, the board will then make a final decision to approve, deny, or approve the application with conditions. If the board does approve a quasi-judicial application with conditions, those conditions should relate to the standards that are being applied and to the land use impacts of the proposed use. As you can see, for most quasi-judicial decisions, the board need only decide by a simple majority. If you have 5 members on the board, you just need 3 of them for a special use permit, an appeal of an administrative decision. But for variances and variances only, we need a 4/5 majority. So we've gotten our evidence. The board has considered it, they've deliberated, they've applied the appropriate burden of proof, and voted to approve with conditions, or deny the application. Now, it's time to reduce that decision to writing. There are different ways that one can do this in terms of the precise mechanics. But what we need to end up with is a document that describes the board's findings of fact, how they applied the facts to their standards, and that describes any conditions that might have been put on an approval. It needs to accurately reflect the decision, the final action that the board took, and the reasoning that got them there. It also needs to be approved by the board and signed by the chair or another authorized member. Now, as I said, there are different ways to produce this written record. Some local governments might have forms or drafts that then are commented on and filled in by the board during the meeting. Others might just put something together after the meeting. Some boards even have, in a separate meeting, a vote to approve the written decision. That's not necessarily required by the letter of the law, but as long as you've got that accurate record of what the facts were, how the board used those facts to get to their conclusion, and it's approved by the board and signed by the chair, then we have a solid quasi-judicial written decision. Now, why is that decision important? Part of the reason why it's important to have a good written decision is that parties withstanding who are aggrieved have a right to an appeal quasi-judicial decisions. Most of those appeals are going to go to superior court, right? They go to regular trial court. And when it gets there, the court does not have its own evidentiary or factual hearing. It sits like an appellate court. In the Court of Appeals and the Supreme Court, we don't call witnesses and testify and have dramatic courtroom moments. It's two lawyers arguing their case. And so when a court is looking at a quasi-judicial decision, what they have to go on is the written record. They're going to look at that record for potential errors in applying the law, like violations of the Constitution, things like conditions that might exceed a local government's statutory authority, something that's inconsistent with applicable procedures that are in the statutes or their ordinance, and other legal errors in the decision. Now there, the court can second guess the board and kind of substitute their judgment. But courts also might review a quasi-judicial decision that has been appealed on the basis of whether there is support in the form of competent material and substantial evidence in the record for the decision the board has made. And if that decision is not supported by competent material and substantial evidence in the record, it might be what we call arbitrary and capricious. That's when we just kind of pick a result out of a hat, basically. So it's important to have a good evidentiary record from your quasi-judicial decisions so that when and if a quasi-judicial decision is challenged and goes to superior court, there's a record that accurately reflects the evidence that was provided and the reasoning that got the board to where they ended up. Now, I'm talking about appeals. Who has standing to appeal? Not everyone can appeal a quasi-judicial decision. A person has to have standing. They have to have a certain kind of stake in the final decision. Usually that means the property owner, right, of the property that's the subject of the quasi-judicial approval application, or the applicant. Those folks, if they don't get the result they want, and they feel that there's been some sort of error of law, or the board made a decision that wasn't grounded in the evidence, then they can appeal that to superior court. Fun fact, a governing board, that's your city council, your board of county commissioners, your board of village aldermen, that governing board of the elected officials can appeal a decision made by their own board of adjustment. It does happen sometimes. So the governing board is another party that has standing. And finally, other property owners who will suffer special damages. That's what the law calls it, suffering special damages. Now, people who suffer special damages are in a very narrow category. Most property owners, even those whose property might go down in value or who might be right next door to the property in question, they're not necessarily going to meet this criterion of suffering special damages. Special damages means it's unique to the property. For example, my house is on a hill and there's another property owner across the street and below me. If I were to apply for a special use permit to turn my house into a much bigger building, then for the most part, people around me, even in my neighborhood, are not going to suffer special damages. But if I'm going to be impacting stormwater flows and I'm going to be, say, trash is going to trickle down onto my downhill neighbor's property, then they're in a unique situation. And that means they would suffer special damages, so they would have standing to appeal a quasi-judicial decision in my favor. So it really has to be a unique situation for someone to be suffering special damages. All right. A couple of notes wrapping up on compiling the record. Again, that consists of the application, the supporting materials, the record of the hearing itself. Now, usually you'll have an audio or video recording of the hearing. If not, then we need to have detailed minutes of the hearing, detailed enough that a court reviewing the record can follow kind of what evidence was presented to the board and how they reacted to that evidence. And of course, any other documents that get submitted, that also becomes part of the record on appeal. And so then, again, a court reviewing that quasi-judicial decision is going to be looking at the evidence. Was there enough competent material and substantial evidence in the record? And what was the board thinking when they were trying to apply this evidence to the standards that are in the ordinance or in the state law? So that is how we decide a quasi-judicial case. It all comes down to competent material and substantial evidence in the record. And it's important to have a good record. It's important to have a good written decision at the end of the process. Thank you for watching.
So that is it for this evening. There are other modules, but I'm holding on to those. Maybe sometime next year, light agenda or cancellation, we might do some more, but I feel like we've done the main ones for now with the legislative and the quasi-judicial. Just wondering, any questions, discussion on anything?
Actually, I do. So if we had the 4/5 majority, if a situation came about like tonight, we have 4 people, would we need to have all 4 present approve for the variance?
You would.
So the 5th person is basically just counting, yeah, okay.
Thank you.
Thank you.
Thank you.
I guess you can, well, you do your next one from there. Oh, well, we don't,
have any public.
yeah, if anyone's here from the public, we could make public comment. I see none, so we will move on.
Okay. I was actually going to do my staff report from up here, which I normally don't do. But this is Community Planning Month. Every October is Community Planning Month. I think in the past, some of you have attended council meetings and been recognized. There have been some changes in rules of procedure as to how the town council does proclamations. But there is a proclamation just kind of for reference, that it won't be presented or read at the meeting, but it is on their next agenda. So I wanted to share that with you, and just share my appreciation for all the work that the board does. I know the town council has a lot of respect and appreciation for all of you as well. You dedicate your time for the betterment of the community and to serve the community. So thank you, and on behalf of the town council, I want to thank you as well. And if you could humor me, I do want to take an opportunity to read to you what will be on their agenda on Tuesday. Again, it's just a reference. There's no presentations, but it will be signed by the mayor afterwards. So it is a proclamation recognizing October as Community Planning Month. Whereas change is constant and impacts all cities, towns, suburbs, counties, boroughs, townships, and rural areas, and community planning and planners can help manage this change in a way that provides better choices for how people live, work, and play in their communities. And whereas community planning provides an opportunity for all residents to be involved in making choices that determine the shared vision of their neighborhoods, and the full benefits of planning requires public officials and residents to understand, support, and demand excellence in planning and plan implementation. And whereas the month of October is designated as National Community Planning Month throughout the United States of America and its territories, and whereas the American Planning Association and its Professional Institute of American Institute of Certified Planners endorse Community Planning Month as an opportunity to highlight the contributions that sound planning and plan implementation make to the quality of our neighborhoods and environment. And whereas the celebration of National Community Planning Month gives us the opportunity to publicly recognize the participation and dedication of the members of the Planning and Zoning Board and other community planners who have contributed their time and expertise to the improvement of the town of Morrisville. And whereas we recognize that many valuable contributions made by the professional planning community and regional planners of Morrisville, and extend our heartfelt thanks for the continued commitment to public service by these professionals. Now, therefore, the Town Council of the Town of Morrisville does hereby recognize the month of October 2025 as Community Planning Month in conjunction with the celebration of National Community Planning Month. So again, thank you very much on behalf of the council. Thank you very much. What you do for the community is important.
Thank you, and we feel the same way about all the staff and all the stuff you do to present things, so thank you.
Thank you. I will share, I have a fantastic team.
Well, you're part of this, but yes, especially you, Brooke, and all of our guardians in the back.
So with that, I'll just go ahead and move on to the newsletter. So since last month, really no new development applications have come in or been approved, with the exception, and the major exception, I think I mentioned this at the last meeting, it had just been approved, Block A of the Town Center developments. That's the mixed-use building. So Town Center Block C, the Town Green was approved, and then immediately after Town Center Block A, which is the mixed-use building across the street, was approved. Going to other news, September 24th was a great day because we had the groundbreaking for Town Center. And again, thank you. You guys reviewed text amendments, reviewed a plan development, you reviewed a development agreement. You guys had a big part in the review, implementation, and just kind of putting your stamp on that project and taking the time that you did with it. But that's a huge, huge milestone for the town, and just great to see that underway. In the affordable housing world, we did release an RFQ for a rental assistance program. We went through that review process, had some interviews. We do have a preferred contractor, can't share with you who that is, but we're nearing in on a contract with someone who will be running that program for us. So that's exciting to be moving forward and taking that next step on that. And then a variety of things going on in the transportation world. So the Safe Streets for All study, that was presented to Town Council at their last meeting. We anticipate its approval at their next meeting on October 14th. That is the study that's actually being done by Central Pines. So they're leading and managing the study, although staff has contributed in a variety of ways throughout. Morrisville contributed 13,000 to it, and that allowed us to be the, model kind of pilot community that they used for the study. So we got some great information out of that study about safety on not just our roads, but other modes of transportation, bicycles, pedestrians, accident history, kind of where the different issues were. So great data to back that up, and then some recommendations for implementation. An alternate transit study and comprehensive transportation plan. So I'm going to hit on the alternate transit study first. We're doing public engagement on both of those this month. So we'll be at the Farmers Market on Saturday and at Boo Bash if you want to come out, taking engagement on both of those studies. For the alternative transit study, it is the last round of public engagement. We're nearing in on final recommendations and taking final input on kind of preliminary findings. So that is coming to a closure soon, but really excited to be doing the first round of public engagement on the comprehensive transportation plan. That plan kicked off in July, but this is the first time that we're really going to be out. We've done, data analysis and, some stuff in the background. But this is the first time we're going to be really out to the public, soliciting and taking in that feedback. So huge milestone for that project. Really excited to truly be, taking that next step and then kicking that off kind of more in the public realm. Again, that study is anticipated to take about 15 months. And right now on your November agenda, we are still anticipating that we will have a presentation for you and be soliciting feedback from you on that plan at the November agenda. So that will be the kickoff meeting with this board. But that is all I have.
Thank you very much. So then we can move on to board comments. Chris?
No comments?
Sandra?
No comments, but I want to acknowledge what you said earlier. The staff of Morrisville does a wonderful job, and thank you for all of your service as well.
Marky?
I'm going to say the same thing. I've worked with Parks and Recs, Culture Resources, so I see all the things behind the scenes. So I really do appreciate all that you do behind the scenes.
So with that being the case, I will entertain a motion to adjourn.
I'll make a motion to adjourn.
Do we have a second?
Yes.
Right.
Yes, I do.
All in favor? Aye. The motion carries unanimously. We are adjourned. Thank you.